Good morning, everyone. The last time I wanted to do this with you, the internet was really bad at where I was. So I will just repeat myself. Now, as I indicated to you, you have a few days. So this is what I intend to do to help you. I'm going to do what you call like a crash revision in the 6 subjects. So I'm starting with the contract. So I have put contract into 4 thematic areas. So team 1, we'll be looking at matters pertaining to formation of contract, offer and acceptance, terms of agreement, intention, consideration, capacity, and probability of contracts. Then team 2, we will discuss terms of contracts and also illegality and public policy. And then team 3, we will discuss vitiating factors, misrepresentation, misduress, undue influence. And team 4, we will discuss discharge of contract and remedies for breach of contract. So you put the whole of contract into 4 major thematic areas. And for each of the thematic areas, when we have finished brushing up the key principles, I have generated just revision questions at the bottom, which we will look at as part of our revision. And then I take questions if you have any contribution. My experience with students is that if we ask you to talk, you don't talk. So I've rather muted everyone. If you want to speak, just raise up your hand so that I will release your mic. And that way, we do not have unnecessary background noise interference. Yeah, so this morning we want to remind ourselves of things that we know. We are talking about enforceable contract. What is it? And how do we establish the existence of an agreement? And what is the usual analysis of agreement at common law? And again, how do we draw the line between agreements that are supposed to have the force of law and agreements that are not supposed to have the force of law, what we popularly discuss as intention to create legal relations? And of course, we need to understand that important common law doctrine consideration and how it has been modified or changed under our law. And we would end this theme by looking at the privity of contracts, and of course, look at some questions as well. So that is the trajectory or the path along which we are proceeding for our first session today. Hopefully, in the evening or night, I may come again online. If you're able to join, that is fine. But anytime you're not able to join, you can always go to the YouTube channel, Ghana Law TV, and you can play back. And I dare remind you that it's the same areas of the law which you are going to be examining on. So all the previous videos or discussions that we have done, which have been uploaded on the Ghana Law TV, are equally applicable. So and that is why I have not bothered so much to do a lot of session with you, because the same law. Okay, good. Yeah, so contract, as we know, contract is a legally binding agreement between 2 or more parties that is enforceable by law. And in terms of the bigger context, contract is quite fundamental, or it's foundational, in the sense that we cannot have the market economy, the laissez-faire economy, or perfect competition existing without contract. Especially so as we understand contract to be based upon free consent of parties, voluntariness or volition, right? 2 parties, 2 or more parties freely imposing mutual obligations on themselves. So that element of volition, free consent, or free assent is very important for contract. And in fact, that is how society, by and large, is organized. Society operates the market principle, interaction between demand and supply, or the price mechanism. And you can reduce the operation of that economic reality to what give rise to contracts. Because simply, I have a cup of tea, maybe a black tea or green tea. You want it, okay? I give it to you, then you give me something in return. So freely, I give you something, freely you give me something, or freely we agree to make an exchange. So that is a reflection of the free exercise of our consent or volition. And we have to remember that the English common law of contract, which we have, goes back to Roman law. And no wonder we all know the maxim, pacta sunt servanda, that is to say that agreement must be kept. Agreement is sacred. Agreement is sacred, or we have what they call the sanctity of promise. Agreements or promises must be kept. Agreements are not meant to be indulged in for games or for games. They are meant to be kept. So pacta sunt servanda. And that is why, if we had time, and of course you've learned this already when you're doing your LLB, Roman law was quite elaborate, having what we call the formal contract in the form of a stipulatio, and which required that contract, even if it's made by word of mouth, should be in a particular format. And again, in the course of time, medieval law, and for that matter, church law, also made impact on contracts. And of course, talking about church law, we go back to Christian ideas. The fact that if you give your word to someone, you have to keep it. I mean, everyday common sense, give your word to someone, you have to keep it. And that is the foundation aspect of contract, because you've promised. So once you have promised, then you must keep that promise. But of course, something may be ringing in your mind. Are all promises meant to be kept? Of course, we are in various situations of life in which promises may be made, but there may not be so much of intention to keep it, as we will see in the course of time. So these ideas actually work together to help emergence of the English common law of doctrine, English common law of contract in the 19th century. And if we are to go into the history, you will notice that at English law, originally, the emphasis was on formal contracts, what you call the contract under seal or contract by deed. And that requires certain formalities. The contract has to be in writing. It must have the seal of the parties. And for that matter, where you produce that, the court could give effect to it. The court could enforce it without requiring you to provide any other evidence. What we later call consideration. There was no need for that because of the formality, because of the solemnity associated with the making or the execution of such a contract. And then we also had what we call the paro contract, also known as the informal contract or contract by word of mouth or simple contract. And that needed not to be in writing or in particular form. It could simply be by word of mouth, or it could be by conduct. And there was difficulty as to drawing the line between what is a genuine oral contract and someone trying to maybe tell a lie and put another in trouble, false claims and all that. So that led to emergence of an element we call consideration, which we'll come to see that where you are seeking to hold someone to a promise which is not reduced into writing with the seal of the parties on it, then you need to do more to convince the court that you are not just making it up. So there was this approach that the English common law was against nudum pactum, that is bare or naked promises, and promises which are a simple one should be grounded in consideration. There should be an element of exchange, a price which is paid for that, and we see that later on. So these ideas, of course, with the historical transference of English law to Ghanaian law through colonial arrangement is what constitutes our law of contract. You know all this already, but as I said, we're just reminding ourselves of things that we know already. So therefore, how do we make a determination as whether an agreement exists? Basically, the law has developed to the stage that as whether agreement exists or not is not so much dependent upon what each party thought. In other words, if you have A and B, it's not whether A is convinced that agreement exists before the court would conclude that an agreement exists between A and B, or whether B is convinced that an agreement exists before the court will so conclude. But more importantly, the court uses what we call the objective test. That is looking at the external manifestations, the words that the parties said, or the actions that they put up. Now, when the words that they spoke to each other, or the actions that they put up or manifested, are put together, and we try to make sense of them, we try to interpret them from the point of view of a disinterested, reasonable person, a third party. What would a disinterested bystander or third party will make of those words which the parties say to each other, or those actions which the parties embark upon in relation to each other? Now, if those words, those actions objectively considered, that is considered from the point of view of a third party who has no bias whatsoever towards any of the parties, is such that the parties by their words or actions should be understood to have made a certain agreement, then certainly the court will say that an agreement exists, regardless of whether in the subjective mind of one of them, agreement did not exist, or in the subjective minds of both of them, agreement did not exist. So it's not so much about their subjective intention, that is not what was going on in the mind of each of them, but the things that they said, the things that they did, when they are considered from a very neutral point of view, whether we can see that there was an agreement, whether both parties could be understood to have assented to certain things by the other party, then an agreement exists. So that is the objective test. And so talking about an agreement, we traditionally analyze it by trying to find out whether we have an offer, whether we have acceptance. And offer, as you know by now, simply a definite proposal or expression of willingness to be bound on certain stated terms, if those terms are accepted by the other party to whom they are addressed. And the offer is made by the offeror or the promisor, then is intended for the promisee or the offeree, as the case may be. And you have a lot of cases. If for nothing at all of us are familiar with the case of NTAC against entry, and which is a Supreme Court decision, and it's be an authority you can cite for so many propositions in relation to offer and acceptance, so to speak. And again, acceptance at this stage, we remember, is an unequivocal, that is unambiguous agreement to the terms of the offer by the offeree. And the emphasis here is unequivocal, that is, it should be definite. There should be no qualification. And that is why later on we say that acceptance must follow the mirror image rule. Just as if you stand in a mirror, you don't expect to see any other thing apart from a true reflection of you standing in the mirror. So therefore, if you stand in the mirror and you begin to see a computer or you see a goat. That is supernatural manifestation. That is not the mirror principle, because mirror principle means that the reflection of the image of the object, which is put in front of the mirror. So in the same vein, offering acceptance, the offer is a definite proposal. So if you are accepting it, you also assent or you approve the definite proposal as made, no more, no less. So that way, we can say that there is a meeting of minds of the parties, because one party has actually made the definite proposal, and then the other party has accepted that definite proposal as made. So there's that mutual assent, what they call the consensus addendum. There's a meeting of what? Of minds. And that is where, if you look at the cases of Smith and Hughes, remember the old oaths and the new oaths, where the parties made a contract. One party thought that what was being offered for sale was an old oath, and another party thought that what was being purchased was like the new oaths, and so on. And the court said that, well, it's not so much about what each of the parties thought, but then we have to look at the position of the reasonable person when they were negotiating to buy oats. If a disinterested third party, the reasonable person was there, would the reasonable person have understood them to have agreed on old oath or new oath? So that is the test of the matter, and not what each of the parties individually thought, as it were. Of course, we all know the case of Ekali and Kabole smoke ball, which remind us that when it comes to offer, especially where it is in relation to potentially unilateral contract, the offer can be made to the whole world, contrary to the arguments which was made by the defendant company in that particular case. Again, yeah, so let's take this and see a bit few more ways. So offer, as we have seen, definite promise. And this definitiveness or this finality is important, especially when later on you come to distinguish offer from what we call invitation to treat. Because as we know, invitation to treat is not an offer, but it looks like an offer, okay? Invitation to treat looks like an offer. It's not an offer. So how do we distinguish that from an offer? The important or the critical distinction is the fact that an offer has an element of finality. That is to say that there is no room for negotiation. Let me see. No, that is to say that the maker of the offer, call him promisor or offeror or covenantor, however you call him, that is fine, is saying that I am committed to be bound by these terms that are proposed. If you are prepared to accept them, that is it. So that's element of finality. There's no room for negotiation. But then when it comes to invitation to treat, you notice that that requirement of finality is lacking, is missing. And there is still room for negotiation, or there's still room for the offeror to consider his position, as the case may be. And that is why we say that invitation to treat is not binding, because it's not an offer. An offer has finality. So if offer is responded to favorably, in which case there's an acceptance, an agreement will come into being. So let's keep that in mind. And again, an offer, another characteristic of offer is that there should not be vagueness. There should be certainty. Okay, so later on when we are discussing terms of contract, you notice that certainty of terms are very important. What is contained in the offer should be clear, should be certain, should be unambiguous. So therefore, where you have a vagueness, where there's that lack of certainty, as happened in the case of a Gattin against a Len, the court will say that there's no binding offer. And again, there should be communication of the offer. offer should be communicated to the offeree. Of course, if you have made a proposal and the other party to whom you are making the proposal is unaware of it, how can he know that there exists a proposal? Now, on this issue of communication of an offer, there are two dimensions which should be appreciated. First, where the offer is in the context or in the situation of potentially bilateral contracts. Of course, there will not be so much difficulty as whether the offer has been, communicated or not. Because if I intend the offer of my car to you, Akwesi or Ajwa or Ama, certainly you will know about it. But the real difficulty occurs where we are dealing with potentially unilateral contracts, in which case the offeror has not indicated the proposal for any particular person. And that is where the situation of Kale against Kabali Smoke Ball become quite instructive. As you notice, they advertise anybody who will buy the product, smoke ball, and use it according to the prescribed usage and get the certain stated the side effect was going to be compensated by money. And to show seriousness of our intention, £100 will be paid. We have deposited £1,000 with the designated bank in London. So these were the terms of the advertisement containing the offer. So ordinarily, one would have argued that, yes, the offer is not for anyone. The court, in the House of Lords, agreed and said that, yes, the offer is valid and it will be responded to by anyone who do the required act, as it were. But when it comes to this potential unilateral contract, like the one that I have explained, the difficulty arises where a person has performed the required act, but he or she was not aware of the offer. Well, if we look at the cases like R and Clark, there's a school of thought that where you perform the required act without being aware of the promised reward, that is the offer, then you are not entitled to it because you did the required act in ignorance of the promised reward, in ignorance of the offer. Of course, that is an old Australian decision, but there's also a school of thought like Williams and Cowardin, and also the US case of Fitch and Senedeca, which are to the effect that so long as the person has carried out the required act, the required action, then it does not matter whether he or she saw or read advertisement which contained the unilateral offer before he did it. He will still be entitled to it. Yeah, so there are two schools of thought. So assuming in examination, you have like a question, a good student will need to present these two contrasting positions of the law. And having presented it, of course, if it's an essay question, then it's not a big deal. You just present them. Now, if it's a problem-based question, you need to present this contrasting position of the law, and then you adopt one to resolve the factual scenario that will be given. So that is the way to go about it. Of course, we have made the point that it is important to have a valid offer. The finality of the intention to be bound should be there. And I said that when you are trying to distinguish offer from invitation to treat, that is the crucial element. And that is why you look at advertisements, okay? Advertisements, we don't jump to conclusion that all advertisements are invitation to treat. No, that will be a mistake. as to whether advertisement is invitation to treat or an offer is very much dependent upon the wording of the advertisement. And that is the approach which was used by the English court in the case of Carlick against Cabolis Mobile, and then the case of Partridge and Crattenden. The case of Partridge and Crattenden, you also remember about the sale of the cock or the the cock or those animals. If you look at how the wording was, the court was of the view that that was an invitation to treat and not an offer. So it's very much dependent upon the wording. So as to what the advertisement give rise, so don't just jump to conclusion that every advertisement is invitation to treat, or every advertisement is an offer. No. It's very much dependent upon how it is worded. If the wording of it is said that there's that element of finality, the intent to be bound, then that is an offer. Yeah, of course. In trying to distinguish between an offer and an invitation to trade, it's not only advertisement. We can also take the issue of like an auction. Okay, you remember auction, where you are having an auction under the PNDC law on the auction sales. The position of the law is that if the auctioneer, for example, makes requests for people to make a bid, the bid that they are making is just what do you call it, an offer, which may be accepted or rejected by the auctioneer. So the auctioneer's request for bids is invitation to trade, so to speak. It's not an offer. It is you, the bidders, making the bid, which is the proposer or which is the offer that may be accepted or rejected by the auctioneer. And the auctioneer will do so by knocking down the hammer. That is the means of communication being used at the auction sale, as it were. And of course, if you look at the broader common law, historically, we used to have like the cases like the Harvey and Fassé, Harris and Dickerson and all that, as whether an advertisement that an auction is going to take place at a particular date and particular time. If it does not take place, will those who travel to the designated location be entitled to recover their expenses from those who had advertised that there was going to be that advertisement? Well, the position of the common law was that no. And of course, this is based upon policy reason. Just imagine if you had so many people going to the place and later on coming to make a claim as to whether how what you call it, the floodgate effect. And that is why the common law is probably that way. Okay, offer may come to an end. So we have termination of an offer. And typically, examination, students may be invited to discuss the moods or the ways, circumstances under which an offer may be terminated. So revocation. Revocation simply means withdrawal. And the position of the law is that an offer may be revoked or withdrawn at any time before acceptance. So that one is straightforward. But where you have withdrawn the offer, same must be communicated. If it's not communicated, then the revocation of the withdrawal is not complete. And authorities like Bryan against the Van Tienhoven to the effect that where you have actually revoked an offer, the revocation is not effective until it has been communicated. But remember cases like Dickinson and Doss, which are to the effect that the communication of the withdrawal of the offer or the revocation of the offer need not be made by only the offeror, but any person with the proper authorization whose information can be relied upon as to whether the offer can be withdrawn or not. That can also suffice as a means of communicating revocation or termination of the offer, as we know. Another way by which the offer may be terminated is through rejection, or what we popularly know as like the counter offer. Rejection is, of course, very logical. An offer is eliciting acceptance, but you can also choose to reject it. So when you reject it, then automatically that particular offer has come to an end. And as I said, a typical way of manifesting rejection is what we call counteroffer. Counteroffer simply means that someone has made an offer to you. Instead of you responding to the offer and accepting it as made, in accordance with what we call like the mirror image rule, you decide to also make another offer, independent of the offer which have been made to you, which you are supposed to accept. Now, because you have made another offer, your offer will be interpreted as rejecting the first offer. And the first offer is no longer available for you to accept. And for that matter, as soon as you made the counter offer, nothing prevents the offeror from giving the offer originally meant for you to another person. And when you even have like a change of mind, the offeror cannot be held liable for having given the offer to another person, because your counter offer effectively destroyed the original offer. And that was the typical scenario in the case of Hyde and Rich, as you can see, about the sale of the farm, the £1,010 offer, and then the 950 counter offer, as it were. Another means by which an offer may come to an end is through lapse of time. So lapse of time simply means that where a period of time has been prescribed for the offer, then as soon as that period has elapsed, then the offer is also considered as having elapsed or as having come to an end. And again, where there is no particular period of time prescribed, then the position of the law is that after expiry of a reasonable period of time, the offer will be considered as having come to an end. So let us keep that in mind. And of course, this can be a whole question on its own. So it's something that you may want to pay attention to as you do your revision. Death or incapacity of the offeror. Before I move on to that, the lapse of time, let me also indicate this. If we look at our Contract Act, especially Section 8, subsection 1, if you contrast that with the common law case of Rutledge versus Grant, Rutledge versus Grant, as you remember, the position of the common law was that where an offeror has expressed the offer to remain open for acceptance within a particular period of time, the offeror or the promisor is not really bound to keep it for the said period unless the offeree has provided consideration. In other words, unless the offeree has bought the option or has done something to justify why the offeror should keep the offer for the period given. So that is the common law position, as we see in the case of Rutledge versus Grant, and Dickinson and Dawes and so on. However, as you very well know, under our Ghanaian Contract Act, 1960 Act 25, if you look at Section 8, subsection 1, the position of the law is that where there's a promise to keep an offer open for a period of time, that promise shall remain valid, even in absence of consideration provided by the offeree. Meaning that under Ghanaian law, if you say that an offer is going to remain valid for, let's say, 1 week, you are bound by it. You cannot withdraw it until the 1 week has elapsed. And if you withdraw it before the expiry of the 1 week, you could be in a breach of the collateral promise to keep the offer open, as it were. And the authority is Section 8, subsection 1 of Act 25. So let's keep that in mind. What about death or incapacity? Well, As far as death or incapacity is concerned, as whether it can terminate the offer or not, it's not automatic. It's very much dependent upon the nature of what was offered. If, for example, the offer is something requiring personal performance of the offeror, then certainly personal performance is not possible once the offeror is not alive. But if, for example, it's about, like, let's say, the sale of land and other things, and the offeror is dead, but there's evidence that yes, he made such an offer within a certain period and so on. It may well be that, let's say, that you even have like a letter or some correspondence reflecting the offer made to you. The offeror has died. That will not automatically bring an end to the offer. The offer can be accepted because it can be applied against the estate of the disease, as it were. Okay, we also have acceptance, and as you notice, you need the coming together of offer and acceptance before you can have like an agreement, the coincidence of offer and acceptance. So you've seen what an offer is. Acceptance, on the other hand, is a final and unqualified assent to the terms of the offer. So you notice that on both the side of the offeror and the offeree, there's this requirement of finality. The offeror is supposed to be final in his proposal. So that is his final position. And then the offeree is also supposed to be final in his response. So that is why acceptance is the final, unequivocal, unconditional, unqualified, unambiguous assent or endorsement to the terms of the offer. And we have indicated that the mirror image principle should be observed. That is, the acceptance must match the offer exactly without any variation whatsoever. And if there is any attempt to vary or change the terms of the offer, that will give rise to what we call the counter offer and not acceptance, as we saw in the case of Hyde and Rich as it were. But of course, we have to draw a distinction that it's not all the time that a request by offeree in response to the offer may be interpreted as a counter offer. Authorities like Stevens and McLean, as you know, are to the effect that where there is a mere seeking or genuine request for information, for example, you want to find out whether the offeror will accept maybe a particular instrumental payment and so on, or whether the offeror will accept, let's say, a split payment. Maybe give you part cash, maybe part something. If you are genuinely seeking information and you are not trying to vary the material terms of the offer, then that will not be treated as a counter offer. It will just be a genuine or mere request for information. And Stevens and McLean's hold the view that that is not counter offer, which is contemplated in the Hyde and Wrench, as you know very well. Now, just like offer, acceptance must be communicated for it to be effective. Acceptance must be communicated for it to be effective. And that is to say that the offeree must bring the acceptance to the attention of the offeror. And here, we must also remember that in law, it is not correct that silence means acceptance. No. Silence of the offeree cannot be interpreted as what? Acceptance to the offer. The only exception is that where there has been a previous course of dealing, maybe the parties have, the same transaction, the party have done it before, and then they understand and says, okay, when I put in the request, maybe in a week or two, if you don't come back to me, I'll just go ahead and supply, thinking that you have no objection. Now, that can be a legitimate mode of communication of acceptance because the parties have previously dealt on that term, so they have agreed that that could be the means of what? Acceptance. And that is why the court deprecated the practice in the case of a felt house against Bandley. If you remember, the uncle and then the nephew, where the nephew had the horse, the uncle was interested in buying. The uncle told the nephew that, if I don't hear any more from you, I will assume that you have agreed to sell the horse to me at so much and so on. Now, later on, unbeknown to the nephew, the nephew has not actually, received the letter or heard it, went ahead and then made those who were auctioning his property sell it. When the uncle saw to sue them for, total conversion and all that, the court said that, well, the uncle could not unilaterally impose silence on the part of the offeree as a mode of the nephew being offeree communicating his acceptance to the uncle. But as I said, the exception is where the parties have previously agreed that yes, silence could be a mode of communicating acceptance. Now, a major exception to the rule that acceptance should be communicated is what we know as the Postal rule. And as you remember, the case of Adams and Lenson, 1818, developed the proposition that where the offeree has properly addressed the letter containing the acceptance and has posted the letter according to the usual way of posting in that particular community or that place, then the position of the law is that acceptance is considered or deemed to have taken effect from the moment of posting and not when it actually reaches the destination. It reaches the offeror. Of course, the policy rationale for such a position is that the offeree does not control the postal system. So if the offeree has complied with the accepted convention of posting, then he or she should be relieved from the burden of ensuring that it gets to its destination when it is really beyond his control. That seems to be like the wisdom under the postal rule. We see in the case of Adams against Lenson. But there's an exception to the postal rule at common law. The postal rule does not apply where the mode of communication is instantaneous. That is to say that where the offeror communicated the offer using instantaneous mode, like maybe telex or fax, then the position of the law is that the offeror must actually hear or receive the communication of the acceptance by the offeree before the acceptance will be considered to be valid. So unlike the postal rule where once the offeree has done it the usual way, it takes effect from that moment. No, in instantaneous mode, it must actually reach the offeror, as we saw in the case of Entos Limited against the Malfa East Corporation. As remember, the offer made from Amsterdam and then received in London, then there was a dispute as whether the contract was made in London was made in Amsterdam. So it was within that context that the English court propounded the proposition that where you are using instantaneous mode, then the acceptance is not effective until it has actually been received by the offeror. And if you remember, Lord Denning went to the extent of using the aeroplane which is passing by. That if, for example, somebody shouted, "I offer you this," and then the aeroplane passed by and you also shouted, and because of the noise of the aeroplane, it drowned the communication of your acceptance. Acceptance is not meant to have taken place yet because the offeror did not hear it. So that is the traditional position. Now, this aspect of the law pose challenge to the electronic mail, what you call the email, because the email is quite recent. And if you look at the these common law decisions and exceptions, they predated the introduction of the email. So there has been a debate as whether the email should be governed by the postal rule or it should be governed by the exception to the postal rule, the instantaneous mode of communication. Now that debate has been going on, and there are a plethora of academic scholarship around that, but we will not allow that to detain us here. Suffice to say that here in Ghana, we have actually overcome whatever conundrum or challenge which this particular area of the law presented. Thanks to our lawmakers, what we have the Electronic Transactions Act, as remember. So if you look at the Electronic Transactions Act, you will notice that I'm talking about the Electronic Transaction Act of 2008, Act 772. You notice that our lawmaker has actually provided a very good solution to this problem, and you go to provisions like can look at the section 50, look at the sections 18, section 20, 23, for example. But essentially, when you look at all these provisions, section 18, section 19, 21, 23, 22, and even 50, the substance of all these provisions is that where a person is making electronic transaction or e-contract, electronic contract, whatever, and you send an information, be it an offer or be it an acceptance, and that information, for example, is sent out of information system under your control and enters into another information system, as it were, then as soon as it leaves the information system under your control, you are deemed to have actually sent the information from that moment when it left your control. And then the other party, that is at the receiving end, is deemed to have received the information at the moment that the information entered information retrieval system under his control. So in relation to email, where you have actually clicked send, the email will go out of your server. It leaves your control. It enters the general pool. So if you want to know when you actually communicated your acceptance or the offer, as the case may be, we are going to reckon it from the date and time that the mail was sent from your email system. In the same vein, if you need to find out when it actually reached the offeree, or when the offeree or the other party received the communication or the offeror received it, you are going to reckon it from the date and the time it actually entered the email of that party, and not when he or she read it. So know the difference. So if you have like a problem-based question and says that the email entered or the email was read at this time, don't use the date and the time of the email being read as the date or time during which the person was considered by law to have received the communication, because that is not what the law says. And as you can see, from the Electronic Transactions Act. For example, it's quite, so if you look at section 19, for example, section 19 says that, quote, the time of receipt of an electronic record shall be determined as follows. A, if the addressee has designated information system for the purpose of receiving electronic records, receipt occurs at the time when the electronic record enters the designated information system. So if it's email, for example, when the time that entered your inbox, that is the time. If it is a fax, the time that the fax machine received it, that is the time. And we're not talking about when you actually read it. So let's keep that in mind. Or if the addressee has not designated information system, receipt occurs when the electronic record enters an information system of the addressee, through which the addressee retrieves the electronic record, just like the one that I explained. Then two, an electronic record is deemed to be dispatched at the originator's registered place of business and is deemed to be received at the registered place where the addressee has his place of business, unless otherwise agreed by the originator and the addressee. So here, we are talking about, let's suppose that I'm a company, okay? And my company is registered in Ghana. Now, as I speak to you, I'm listed in another place. If I have sent an offer, and we need to find out, but the person was not in Ghana when he sent the offer. So is the offer considered as having been sent from Ghana or from where I am? And again, if I meant it for you, and let's say that you two, you're not in Ghana, you've left for another place, let's say Afghanistan, and you open your email there, should we treat our contract as having been made in Ghana, Afghanistan, or at wherever I am? So to have, and that was the problem we had in the case of Entos against Malfa East Corporation, if you remember the first well. So to avoid that, our lawmakers in the Electronic Transaction Act, per section 19, subsection 2, have solved it, saying that, yes, in a situation like that, we will consider your electronic record or communication for the purpose of the transaction as having been received at the registered place. So if Ghana is the registered place, then regardless of the fact that I sent it when I was in I was in Togo, or I was in Afghanistan, or I was wherever, that is the place where the mail or the transaction is said to have been made. So let's keep that in mind. Yeah, let me see if there's any hand before I move on to intention. Okay, there's no hand. Somebody scratched the screen. Does it mean you wanted to speak? Or it was a mistake? Okay. All right, so we move on to, but just before I leave offer and acceptance, there's this particular aspect of it which, as a teacher, when I used to teach this course many years, I used to examine students on, and I don't know whether your examiners may have similar interests as I do, what they call the battle of forms, okay? The battle of forms. You've heard of like the case of the Badler Machine Tool Company against SLO Corporation. A very interesting case. We have sellers who offered to supply the buyers a machine for amount of money that's specified. The sellers communicated their offer to the buyer using a particular trading form which they had. And then the trading form that they used to communicate their offer to the buyer that they're able to supply, the machines to them and all that. That form had what we called a price escalation or price variation clause, as it were. meaning that under certain circumstances, the price may be reviewed upwards to reflect inflation and other things. So this was the form that the sellers used to make their offer known to the buyers that they are prepared to supply the machine to them at the stated price and so on. Now, when the buyers were replying this offer by the sellers, they also place an order for the sellers to supply them the machine. And the buyers also have what they call their own requisition form, like their own form for placing orders for supplies to be made. Now, if you look at the form that the buyers use to place the order, they don't have any price escalation or price variation clause on it. What they had on their form towards the bottom of it was a tier of acknowledgement form. That is portion of the paper that you could tier, okay? And in the portion that you could tier, there were words like, we, the sellers, accept the order on terms and conditions stated herein. So meaning that the buyers, are using their form to send to the sellers that they should send them this. And then the sellers are supposed to sign and take that portion off. Now, the sellers did that and they supplied it. And later on, a question arose as to, the sellers, they needed more money than the actual price because of a change in circumstances. And then the question arose as to whether they were actually bound by the buyer's terms. If you are using the buyer terms as per the requisition form that the buyers use, the buyers forms did not have any price variation, meaning that the price at the time that you place the order was the final price and fixed. It could not be increased. On the other hand, if you take the view that the contract made between the buyer and the seller was actually governed by the form which the sellers had used in communicating the offer to them, then the price could actually change because in the seller's form, there was a price escalation or price variation clause. Now, that was the difficulty. During the trial, the trial judge took the view that the contract should be understood as having been made on the seller's term. That is, it is whatever is contained in the seller's form, which should be considered as the terms of the contract made between the seller and the buyer, and not the form which the buyers use in placing the order. Of course, this was appealed against, and during the appeal, the court, among other things, took the view that, excuse me, in a situation like battle of form, that is, the two parties having different forms and trying to say that it is this form which governs the contract, and that you need to have a holistic approach in looking at them. And in that respect, the appellate court was of the view that the decisive document was the acknowledgement form that was completed and returned to the buyers by the sellers. And this will definitely be the one which the seller sent. And they took the view that the buyer's order was not acceptance of the seller's offer found in the quotation. So they use what they call the counter offer analysis, that the buyers had actually made a counter offer. So if the sellers actually signed subsequently and returned to them, then the seller should be taken as having accepted the offer made by the buyer. So it was rather the buyer's terms that were applicable and not the seller's term. So the most important thing to note is that the court was trying to use the offer and acceptance, the counter offer analysis that we know. That, okay, if we say that the sellers were the first to send the offer form with the price variation clause, according to the mirror image rule, the buyers should have just accepted it just like that. But here is the case, they did not just accept it. They also issued their own requisition form. And the requisition form had some material variation from what the sellers had. And not only that, they also had the tier of a portion that the sellers were supposed to sign as acknowledging that they have received the buyer's requisition. And then the court said, okay, what the buyers gave was a counter offer to the offer by the sellers, so to speak. And for that matter, if the sellers had actually signed the tier off and taken it, they are deemed to have accepted the counter offer, so to speak, made by the buyer. So the agreement between the buyer and the seller was governed by the buyer's terms and not the seller's terms. So there was no price variation clause, and the price could not change as the sellers had wanted. So just keep that in mind. Okay, so we come to, and in the last but I think the last but three topics for team one in this session. Intention to create a legal relation. This is important as it helps us to draw the line between agreements that are meant to be legally enforceable and agreements that are not meant to be legally enforceable. And sometimes you hear that every contract is an agreement, but not every agreement is what is a contract, and so on. Part of that is largely to do with the intention to create legal relations, as it were. So when it comes to this, as you know very well, the law puts contract into two main categories. On the one hand, we have like the domestic and social agreements, and then the other, we have the what you call like the commercial agreement. And the position of the law is quite straightforward, that in the case of domestic and social agreement, there's a presumption that the parties had no intention to create legal relation. In other words, the starting position of the law is that the parties did not want the agreement to be legally enforceable. And mind you, I said presumption. And this presumption is rebuttable, meaning that it is not conclusive. It is not inflexible. It can be displaced. And you know the case of Bafo and Bafo, the husband and wife, and then the husband agreeing to pay allowance, not paying. Subsequently, he defaulted. The matter came to court, and then the court said that because having regard to all the circumstances, they were married. If you look at the context in which it was made and all that, the husband, they were working outside UK. They came. The wife was not well. The wife needed to stay and get more medical treatment. And the wife didn't want to stay. So the husband had to convince the wife to stay and promise to send her remittance periodically. And the court said that if you have regard to all that, there was no intention to create binding legal relations, so that was not enforceable. So Bafo and Bafo. But then, as we know, the other situations, merit and all that, where the parties, let's mind you, it's not because the parties are not married. No. If you look at the detailed circumstances, married and married, for example, the parties had not completely divorced. They were still in the process of separating. And again, the parties reduced the agreement into writing and all that. So based upon all those pieces of information, the court took the view that despite the fact that you could classify them under social and domestic agreement, there was enough evidence to rebut the presumption of no intention to create legal relation. And for that matter, there was intention to create legal relation in that circumstance. The evidence was so overwhelming. Now, if we look at the flip side, commercial agreement, the starting position is that there is intention to create a legal relation. So that is the starting position. So that's the reverse side of the social and domestic. Social and domestic, the starting position is that there's no intention, but here, the starting position is that there's intention, as we saw in cases like ESO Petroleum against customs and ESO Petroleum against Martin and all that. But just like the social and domestic agreement, this presumption can also be overcome. So despite the fact that you're dealing in commercial setting, there could be times that the parties can put up enough evidence to show that despite the fact that we are in a commercial context, we do not intend to be bound. So that is also possible. And typically when it comes to what we call the honorable pledge clause, you can have a MOU, memorandum of understanding, and so on. And then the parties may put in a clause that this agreement is intended to be binding only in honor, meaning that we don't expect that any of us will rush to court or to arbitration for it to be enforced, as it were. Yeah. So in rebutting the presumption, whether in the case of commercial contract or social and domestic contract, what we should remember is that it is the terms, the actual terms, which are important. This categorization that we have, they are not cast in stone. But all the time, what the wording or what is actually contained in a particular agreement is what will be construed, what will be interpreted to mean whether there was an intention to create legal relation or there was no intention to create legal relation. So let us keep that in mind. So, for example, when it comes to even commercial contract, where we have subject to contract, okay? So sometimes you can have what they call a subject to contract agreement. So this agreement is made subject to contract. Now, where you have something like that, what it means is that the arrangement the parties are entering into are in preparation or in anticipation of a more formal contract to be crafted or executed subsequently. And for that matter, that subject to contract may not be interpreted as, if you like, having the intention to create a binding legal relation. So let's keep that in mind. And of course, we've talked about the situation in the social domestic agreement that if there is evidence that the parties intended to create a binding contract, then that will be. And we cited merit and merit. And as I said, it's not so much because there was marriage or there's no marriage. No. The most important thing is that if you look at all the circumstances, do we have evidence which suggests that these parties, regardless of their social and domestic context, intended to be binding, to have a binding legal relationship? If the answer is yes, then the presumption is rebutted. Okay, so we move on to consideration. Unless there is a question, and I don't see any. Okay. Okay, so Consideration, as we have explained over and over again in previous lectures and recordings in your various schools, is the price paid by one party for the promise of another. But before we move further, we need to properly contextualize. We need to put it in the proper perspective. In talking about consideration, you must always go back to a distinction between a contract under seal, also known as a specialty contract on one hand, and a simple contract, also known as paro contract on the other hand. And the position of the law is that where you are dealing with specialty contract or contract under seal, there is no requirement for consideration. The reason being that a contract under seal has certain important formalities which put beyond doubt as whether the parties actually entered into binding, enforceable agreement. And what are these formalities? The fact that it should be in writing, the fact that it should have the seal of the parties, or the signature, or the authentication mark of the parties. These are solemn acts which are enough for the document containing it to be given effect as they are. So that is why we say that there's no need for consideration for contract under seal or specialty contract. On the other hand, when it comes to paro or simple contract, there is a requirement for consideration because the courts need to ascertain whether, as a matter of fact, the promisor actually made the promise, which the promisee is seeking to enforce against him. And the only way to do that is to find out whether the promisee, for example, did something in response or in return to the promise which the promisor made. So that is this whole idea of consideration. So once you understand it that way, then it's very simple. So consideration may be executed. And that is where one party performs an act in exchange for the other party's promise. You take, for example, unilateral contract. Unilateral contract, one party has said, okay, I'm giving 1,000 Ghana cedis, anyone who will find my missing bicycle. So you provide the missing bicycle in exchange for the promise to pay you 1,000 Ghana cedis. So that's executed. Then, so if you take let's say that the finding of the, if you take the 1,000 Ghana cedis, right? If you are seeking to, enforce the 1,000 Ghana cedis, the consideration that you're pointing to is the fact that you found the missing bicycle. So that is like the executed act, as it were, or whichever way you look at it from the other side to the same thing. Or when it also comes to bilateral contracts, especially, you have what they call it executory consideration. A promises to give 10 cedis in return for 2 tin of milk, which B will supply in future. So both parties exchange promises to perform an act in future. So that is consideration. Then we also have the past consideration, where a person is trying to rely on an act which he did before a certain promise was made as a consideration for that promise. The position of the law is that there must be a promise before consideration, and not a consideration before a promise. And for that matter, as a general rule, a past consideration is not a valid consideration, or is not a good consideration, because the act of consideration is not referable to the promise. The reason why it's not referable to a promise is that at the time that it was done, there was no promise. So that is the general position of the law. But there are exceptions. For example, as we know, where the particular act, which is being considered as past consideration, was done at the request of the promissor, then subsequently, if the promissor promises to pay a reward or something for that act, the promisee can rely on it because he had done that act at the request of the promissor and in legitimate expectation that some reward or payment will be made. As you know, in the well-known case of Lampley and Brightwaite, the guy who had to use his connections and arrangements to try and travel many times to where the king was to obtain royal pardon for someone who was going to face a death punishment for murder offense. And later on, he promised to pay him and all that. And the court said that yes, because he had been requested to work towards obtaining the pardon, that could be relied upon as a valid consideration, an exception to the general rule that past consideration is not like a good consideration. And another important exception to the past consideration rule is where you are dealing with the bill of exchange, right? Especially when it comes to checks or negotiable instrument, when it comes to check. If we look at the Bill of Exchange Act of 1961, Act 55, there is a provision to the effect that antecedent liability is considered a valid consideration. When we say antecedent liability, I give you a check, okay? I give you a check for 10,000 Ghana cedis. Now, the check that I have given you is a promise I'm making that if I present the check to my bankers will pay you the face value of the check, which is 10,000 cedis. Now, if the check is dishonored, that's a breach of promise by me to you. You can sue me, regardless of any criminal offense, which can be pursued separately. Now, if you decide to sue me for breach of the promise due to the check being dishonored, you'll be confronted with the question, what consideration have you provided? And the consideration you'll be pointing to definitely will be a past act, which you did. It may well be that you had done some services, or you had supplied something to me, right? And in response to that, I issued the check. So here, what you did to warrant the issuing of check actually took place before the check. And the check is my promise that that money will be given to you. So going by the orthodox reasoning, one would have said that that is a past consideration. But the lawmakers in their wisdom have provided in the Bills of Exchange Act 1961, Act 555, that an antecedent liability, that is a past debt, is a good consideration. So that is another exception to the past consideration rule. So let's keep that in mind. The other point to remember is that consideration must move from the promisee to the promissor. That was the original common law position. That is to say that the person who is seeking to enforce the promissor's promise must have provided consideration. And if you've not done that, you could not enforce the promise. And of course, you see cases like Twaddle and Atkinson, right? Twaddle and Atkinson, the contract was between the two father-in-laws. And later on, one of the children sought to enforce the promise. And the question is whether consideration had moved from him to the promissor. And the answer was no. And then the common law said that, yes, that he could not enforce the promise by the father-in-law, that would be paying monthly stipend to support their marriage. But if you look at Ghana, that has changed. If you look at the Section 10 of our Contract Act, Act 25, Section 10, I think I've reproduced it somewhere here. And so if you look at Section 10, for example, which says that no promise shall be invalid as a contract by reason only that the consideration, therefore, is supplied by someone other than the promisee. So is it unlike the common law rule, as reflected in cases of Twaddle and Atkinson, that if consideration was not provided by the promisee himself, but provided by someone ordinarily, that could not be, adequate, sufficient consideration to warrant the enforcement of the contract. Here in Ghana, we have changed that rule, and according to Section 10, a consideration, even if supplied by a third party, can be relied upon to enforce the contract. So let's keep that in mind. Yeah, then we also meet this issue of adequacy of consideration and sufficiency of consideration. So we know and we've been taught that consideration must be sufficient, but need not be adequate. What does it mean? It simply means that the law, and for that matter, the courts, is not interested in assessing the comparative economic value of the consideration. That is to say that it is not the business of the law or the court to try and compare and contrast what the promisor gave in return to what the promisee is giving, to find out whether if what the promisee is giving fairly correspond to what the promisor provided. No, that is not the point about consideration. It's not about weighing the two promises to find out whether this one, in terms of value and all that, fairly compares to that. No, that is not the point. So if that were to be the point, then we'll be looking at what we call the adequacy. And that is why we're saying that the law is not interested about adequacy of consideration. The law is interested in the sufficiency of consideration. And all that matters as far as consideration is concerned is that it should be something of value in the eyes of the law. So long as it is something of value, something not just illusory, something which is not quantifiable. If it's something quantifiable, something of value in the eye of the law, that will suffice, regardless of the fact that it does not correspond exactly to the value of whatever the other party is giving. And that is why, in the case of a Chapel and Co. against Nestle and Co., the court was prepared to recognize chocolate wrappers as sufficient consideration because regardless of the fact that it did not fairly correspond to that, it was something of value in the eyes of the law. But then the fact that the law is not interested in comparing what the parties are exchanging as whether they are adequate does not also mean that you can just present anything as consideration. At common law, certain things were rejected as not being good or sufficient consideration. For example, where you had an existing legal duty. So an existing legal duty here would mean one of two things. One, you have, let's say, a contractual obligation, okay, to perform. Maybe under existing contract, you're supposed to do certain things. If you do it, can that give rise to sufficient consideration? As you know, cases like Stilk and Marrick, okay? Cases like Stilk and Marrick will say that if you perform a contractual duty, you remember the cement, when some deserted and the remaining were actually promised extra remuneration, and later when they were not paid, they sought to sue the captain. And the court said that what they're relying upon was the fact that they continued to work on the ship for the ship to complete its voyage. But that was something that we were already obligated to do. And for that matter, they were carrying out their existing legal duty, existing contractual duty, and that could not be a sufficient consideration. Of course, we know the exception of Hartley and Ponsonby, where in a similar situation, but the court said that because the number of seamen who had actually deserted the ship was quite huge, it was reasonable to assume that when so many people deserted the ship, the remaining seamen should be understood to have entered into new contract arrangements, so novation, with the captain of the ship, and that is why that was enforceable. But of course, if you look at the modern cases like Williams and Ruffy Brothers, okay, if you look at the Williams and Ruffy Brothers, for example, the common law is to the effect that where you carried out your existing contractual duty, but it conferred some benefits on the other party to whom you're already obligated to perform that obligation, or it saved them from some detriment and so on, or it's even put some additional detriment on you, that could be sufficient consideration. So that is the modern variation of the old common law position. And again, at common law too, where you have like a public duty, okay, like a duty under law, such as we saw in the case of a Collins against a Godfrey. Someone had been served with the subpoena. Subpoena ad cificandum, subpoena ad ducis, that is to come and testify or to come and produce a document as part of a trial in court. That is a court summons, court order. If you do not honor it, you could be arrested and punished under contempt of court proceedings. So when you are so subpoenaed, technically, you have no choice but to comply. Now, in that situation, a promise had been made by a person who stood to benefit from the testimony which was going to be given to the other party who had been subpoenaed that should you attend proceedings, I was going to pay you certain money. So the person attended proceedings, and subsequently there was a failure, or there was a breach by this gentleman who stood to benefit from actually doing that. And the matter came to court, and the question was whether the gentleman who attended the proceedings and testified provided consideration. And he sought to rely on the fact that, yes, he attended proceedings, and for that matter, is entitled to the promised payment. Then the court said that, well, under the law, you have obligation to respect court orders, otherwise you could face contempt of court. And all that. So you had just carried out your existing legal duty, and that could not be a good or sufficient consideration. However, the common law moved on and said that in some situations where you have carried out a legal duty and you did more than what the law requires, that could be sufficient consideration. So you look at cases like Glasgow Brothers against Ghanaian County Council, and the case of Sheffield, against Harris and all that. The court to say that if you did more than the law requires, then that could be a good consideration. Or you can even look at the case of probably Kissy enchantment in Ghana to some extent, that Ghanaian ambassador to Liberia, who had to help this Ghanaian company in Liberia to obtain the timber concession and all that. The court seems to be saying that, yes, if you did more than what the law requires of you, then that could be a good consideration. But all this, okay, let me add the part payment problem, and then we'll notice that all these rules have been modified by the Ghanaian Contract Act. But before we say that, there's another aspect of the sufficiency of consideration principle that is in the area of part payment of debt, of variation of contract. At common law, as you remember, the position of the law was that where you were supposed to pay a debt, maybe a certain amount of money, and then the creditor to whom payment was supposed to be made assured you that, okay, pay part of the debt and I'll forgive the rest of the debt. I'll consider you as having paid everything. I'll not demand the rest. Now, subsequently, if he decided to demand the rest at common law, nothing prevented him from so doing. The reason being that the promise he made to accept part payment in satisfaction of the entire debt is considered as not supported by consideration. Unless you had actually done something extra. Before the common law would say that then the promise to accept part payment in satisfaction of the entire debt is actually binding. So you remember like the case of the Pinel's case, the case of Foss and Beer, Dr. Foss and Mrs. Beer, the judgment debt. After Mrs. Beer had assured Dr. Foss that if he will pay part of the judgment debt, then he will forgive the rest of the debt. So Dr. Foss made the effort to pay by a certain installment. As soon as he finished, Mrs. Beer sought to sue to recover interest which had accrued on the judgment debt. And the court said that nothing prevented her from so doing because the promise by her to accept the part payment was not supported by any fresh consideration provided by Dr. Foss. So let's keep that in mind. Now, the way to circumvent that problem at common law is the intervention of equity. Equity intervened in a very nice way. You remember very well Lord Dunning's decision in the case of Central Landing Property against the High Trades Limited, where he revisited the equitable principle of promissory estoppel and made the point that where a person to whom a legal obligation is owed goes out of his way to make a representation or make a statement that he is not going to insist on a straight legal right, and the other party believes what he's saying, and for that matter, arranges his affairs in reliance upon that belief which he has created. Then subsequently, if he decides to go back on his word, if he decides to insist on his straight legal right, equity will preclude him, equity will stop him from going back on his word. So that is the doctrine of the promissory estoppel. And of course, if we look at our Ghanaian Evidence Act, Section 26, where you have made like a statement, a conduct, and same is actually rely or believe upon, you'll be prevented from denying subsequently that you never meant that impression that you had created. Now, the good news is that this common law doctrine of consideration has been substantially modified, under our law. So, for example, if you take Section 9, as you know, has actually abolished the requirement that fresh consideration should be provided where you vary a contract or you modify a contract, meaning that the common law rule in cases like Silk and Marrick, even the Williams and Ruffy brothers, the case of Gramogan and Collins and Godfrey, they are all no longer good law as far as our Ghanaian contract law is concerned. So that is why if you look at Section 9, for example, this is how it reads, quote, the performance of an act or the promise to perform an act may be a sufficient consideration for another promise, notwithstanding that the performance of that act may already be enjoined by some legal duty, whether enforceable by that other party or not. So this Section 9 effectively provides solution to the problem in the case that we saw, Silk and Marrick, which says that if you perform existing contractual duty, that could not be a sufficient consideration. It only provides a solution to what we saw in cases like the Collins and Godfrey, that if you perform a legal duty or duty enjoined by the law, that cannot be a good consideration. Section 9 is saying that all these can be good consideration. So the takeaway is that under Ghanaian law, such as Section 9 of Act 25, where a contract is modified, there's no need for fresh consideration. And of course, we've also seen the fact that consideration need not move from a promissory to promissor. Then, when it comes to part payment, okay, Section A2. Section A2 also says that a promise to waive the payment of a debt or part of a debt, that is what we call the penals case. Section A2 is a solution to the penals case or the rule in Fosambia, meaning that where someone has promised to waive or to accept part payment of a debt, that promise is binding, despite the fact that no fresh consideration is provided by the debtor or the promisee, as it were. Now, my advice to you is that for purposes of examination, examiners find it interesting inviting students to discuss changes or modifications which have been made to the common law doctrine of consideration by the Ghanaian Contract Act. And Mrs. Donna Hammond, now Professor Donna Hammond, my teacher in University of Ghana, many years ago, did a very good article. And of course, the article essentially along, those are what we have discussed in our brief discussion. And if you also read that article, I think that it will deepen your understanding of the changes which have been made to the common law doctrine, so that if you have it as a full question, you are able to do that as it were. Yeah, promissory estoppel, we'll talk about it, so there's no need to belabor that point. Privity of contract. Okay, so privity of contract, the principle is basically that it's only the parties to a contract who can enforce that contract. And also it is only the parties to the contract who are bound by that contract. That is to say that third parties, or to put it bluntly, strangers, cannot sue to enforce the terms of a contract, neither can they be held liable under it. Remember the case of Twaddle and Atkinson, the case between the two fathers whose parents and whose children were getting married, and they agreed to contribute amount of money to support them. The father of the son was paying, the father of the wife defaulted, and at some point he died, and then the son sought to enforce it. And the question is whether he could enforce that contract against the representative of the personal representative of the deceased father-in-law. And the court said that, well, he was a stranger to the contract between the two father-in-laws, so he could not enforce it. In the same vein, the case of a Dunlop against the Dunlop Dematic tie against Selfridge. Remember where the company which had made ties, they were selling it, and then they had this arrangement, that if you are also going to sell it to third parties, you must extract what you call the price maintenance undertaking from them. So they had that arrangement, and subsequently they saw that their tires were being sold in the market at a price different from the price that they had given. So they sought to sue the retailers, as it were. And the question is whether there was any contract between the manufacturers and the retailers regarding the price maintenance. So the court said that yes, going by the primitive rule, we will say that they were third parties, they were strangers, and they could not enforce that contract as it were. But in Ghana, as you know, if you look at the Contract Act of 1925, there has been an important modification or changes to the common law doctrine of privity. And the position of the law in Ghana since then these days is that where a benefit has been created for you under a contract, or where you fall within the class of designated beneficiaries in a contract, by reason of the benefit or by reason of being a member of the beneficiaries, you will be able to enforce the contract, despite the fact that you were not a party to the contract. So Section 5 of the Contract Act provides that, as it were. Yeah, so if you look at the Lord Dunedin's, I think the famous statement in the Dunlop's and Selfridge, you talk about that the law does not know the principle of the jus quotidianum tertio, as a rights acquired by a third party and a common law. But Ghanaian law, Section 5, actually recognizes jus quotidianum tertio. That is, a third party can have a right under a contract if the contract creates a benefit for him, as it were. And of course, we've met Section 10, which says that, yes, if you're a stranger, you've not provided consideration provided by someone, you can still enforce that contract. And so I've reproduced the actual text of the relevant provisions here for you. Now, apart from these statutory exceptions, we should remember that we also have important exceptions to the doctrine of privity at common law. That is to say that even before we consider statutory exception of maybe Section 5, some exceptions already exist. And if you look at the Dunlop pneumatic tie against Selfridge, the court even went out of its way to discuss those exceptions. That is, how you can circumvent the common law doctrine of privity of contract. And these include the equitable doctrine of trust. So trusts, where a trust exists, maybe like a winner of a property, the settlor or the testator has transferred ownership to the trustee and then the trustee is supposed to hold the property for the benefit of some beneficiaries. Now, the contract is between the maker of the trust, that is the settlor or the testator, and the trustee. The beneficiaries are actually strangers. However, in equity, where the trustee is not taking good care of the trust property, and then the trust property is being dissipated or being destroyed, equity recognizes the right of the beneficiaries to intervene in order to safeguard their interests and preserve the trust property from dissipation or destruction. Again, agency only provide another exception to the common law doctrine of privity. How is that exception? Usually, an agent can enter into a contract on behalf of a principal. So principal is someone who has appointed someone to represent him, and the person representing him is called like the agent. Now, the agent can enter into contract with third parties, and the contract made between the agent and the third parties can be enforced by the principal because, in the eyes of the law, the agent was actually acting in the shoes or acting on behalf of the principal. And for that matter, the principal was not there, but the principal will be allowed by agency principle to enforce the contract against the third party as it were. Also, when it comes to a collateral contract, that can also enable someone who was a stranger to the substantive or the main contract to enforce it as it were. And we've seen the statutory exceptions already, so we will not belabor the point. Now, just before we look at the questions, I think I skipped capacity to contract, but just a few words. Capacity to contract, as you know, looks at who qualifies in law to enter into contracts or contractual arrangements. And the position of the law is simply that every adult who is compos mentis, that is, who is of sound mind, is considered as having capacity to enter into contract. So that is the general position of the law. And then question will be, who is an adult? An adult is someone who is not a minor. So who is a minor? Under Ghanaian law, if you look at the Interpretation Act, a child, and for that matter, a minor infant is someone below the age of 18. If you look at the Companies Act, the new one, Companies Act 2019, Act 992, a child or a minor or infant is someone below the age of 18. So unlike the previous time when there used to be debate as to whether the age of capacity is 21 years or 18, in my view, that debate has been resolved impliedly by the passage of the Companies Act, and of course, by the Interpretation Act, when these two provisions are read together. So now, a minor and infant is someone below the age of 18 and not 21. So those who make those arguments, please be guided and avoid wasting your time on those arguments. And then you should always cite the Interpretation Act and then the Children's Act. You know, the Children's Act will say that a child is someone below the age of 18. Now, when it comes to minors, as you know, there are contracts that they can enter into and contracts that they cannot enter into. But then you have to remember that minors are considered vulnerable in the sense that they may be exploited by unscrupulous adults. So the law tries to provide certain safeguards. So a minor can enter into contract for supply of necessaries, right? Like things which are considered suitable to the station in life of the minor. But even when it comes to supply of necessaries, the law still protects a minor. The law says that where a contract intends to contract for supply of necessaries is a valid contract. However, the minor shall pay only reasonable price. The minor will not pay the market or the contractual price, only reasonable price, as it were. And the reasonable price here definitely will be like the real cost of the item, as it were. And you also look at even the necessaries. The definition of necessaries, as you see from the Sale of Goods Act, for example, and also the case law in Nash and Imam will remind you that the court will always look at what is actually needed by the minor at the time that the goods are delivered and not at the time that the contract was made. And as you saw in the Nash and Imam, at the time that the contract was made, it may well be that the minors only needed the 11 waistcoats. However, at the time of the supply, during the trial, there was evidence that the parents had already supplied him some. And for that matter, he did not need them, and they could not be considered as what necessaries. Now, where the law invites you to discuss whether the law which governs capacity of minors contract is, for example, fair or not, we are supposed to explore some of these dimensions. That is why we are looking at them that way. And again, apart from supply of goods, we also have a contract for beneficial service. A minor can enter into a valid contract for beneficial service, especially if the contract is meant to enable the minor get a livelihood in future, like apprenticeship and so on. But where such a contract contains harsh and onerous terms, then that contract will not be binding or will not be valid. Remember the case of Di Francisco and Barney and all that. Of course, we also have those who suffer from okay, the last time there was a question, and I think there was a loan. We know that when it comes to loan, a minor cannot enter into a valid contract to take a loan. And that is why in Ghana, when you have the student loan scheme, PNDC law, I think the 230-270, there was a provision to the effect that where you are a beneficiary of the student loan scheme, you are deemed, that is, you are presumed to be of full age, meaning that, and that provision was against the backdrop of the common law, that a minor or an infant cannot enter into valid contract for loan, as we see in the case of the Imperial case. Yeah. Now, with respect to people who suffer from insanity or lunatic, position of the law is that where they entered into a contract during the lucid intervals, then that could be binding. But always we have what they call it the reverse burden of proof. If they can lead evidence to show that at the time that the contract was made, they were not actually sane, and for them, they didn't appreciate what they were doing. That may lead to the court coming to the conclusion that yes, the contract is not valid unless there can be a countervailing evidence by the person who's seeking to enforce the contract to rebut what they will have done. In the Ghana Law TV, I have full discussion or full lectures on almost all these topics, and that is why I am very sketchy in my discussion. The assumption is that at this stage you have learned all this, and we're only helping you to mop up. Good. So let's look at some of these questions. Critically analyze the role of the postal rule in the modern digital age within the context of Ghanaian contract law. To what extent is this rule still relevant, or should it be reformed to accommodate electronic communication? Now, if you have a question like this, pretty straightforward, provided you understand communication of acceptance, as we've discussed it. So you need to tell us that a postal rule applies in relation to communication of acceptance. In communication of acceptance, the requirement is that acceptance is not valid unless it is communicated, that is made known to the offeree. The postal rule emerged as an exception to that rule, that where the offeree is posting or sending the acceptance via post, then so long as that he or she has properly addressed the letter and posted in the usual way, then according to Adams and Linsell and related the case law, communication is said to have taken place from the moment of the posting and not when it actually gets to the offeror, as it were. So that is the essence of the postal rule. And the policy rationale seems to be that once the offeree has complied with the convention or the practices for posting, then the offeree should be spared the burden of ensuring that it actually gets to the offerer, because the system of transmission is beyond the offeree, as it were. So that is the wisdom under that rule. Now, that rule certainly developed at the time that not so much progress has been made with respect to digital communication. So in digital communication, there has been a concern as whether the postal rule should be applicable or should not be applicable. And we should rather have like the instantaneous mode of communication, as we have in the NTOS and MIFA Corporation, that where you communicate your acceptance using instantaneous mode like the telephone, telefax, and so on, then communication must actually reach the offeror before same will be considered as having been effected. Now, you need to make the point that if you look at modern digital age, especially email, to a large extent, the situation or the context of postal rule is very much applicable. How is it? If a person is sending, let's say, email, after he or she has used the correct email address of the intended recipient, and he or she has actually hit the send button and ensure that it is sent out and it's not just in its outbox. If it's in outbox, it means it has not left your destiny. But if it's in the send box, it's actually sent. Now, once it is sent out, the rest is beyond the control of the sender. And that is why the position of the law with respect to postal rule may reasonably be applicable to the digital age. And then you make the point that under Ghanaian law, the situation has already been resolved under the Electronic Transactions Act. And then the various provisions that we'll be discussing this morning, that you go back to them. And I think that that should be a good discussion. Any question or further input on that before we move on? You can put up your hand, okay? Yes. Unmute yourself, Muhammadu.
Sir. Okay, sir. Sir, please, with regards to the contractor age, I don't know whether Donna Hammer, the book there maybe
No,
is
maybe, do you know something?
Yes, sir.
We've moved beyond general questions. Now we are dealing with specifics. So what if I say if you have something, I mean what you have done, the question one. So when we finish what I have and we haven't addressed the general one, then we come back to otherwise you confuse. So this particular one, if you have anything to add to it, that's what I mean. The question one.
Okay, no. Oh, no. Then thank you, sir.
Okay. Anybody? Okay, is there any other hand? Okay, nobody. Okay, question two. Discuss the significance or distinction between an offer invitation to trade in contract law. How has Ghanaian jurisprudence addressed the situation where the distinction is blurred? So we've been discussing this also this morning. So question like this, straightforward. First, explain what an offer is. Then explain what an invitation to trade is. We have seen that offer is the expression of willingness on the part of the offeror or the promisor to be bound on what stated terms or definite proposal. An invitation to treat is an invitation extended to a party to make a proposal, which may be accepted or rejected. Then you make the point that the critical distinction between the two is the element of finality of the proposal or the intention of the maker. So then the maker of the offer is final and definite regarding the proposal and his commitment to be bound. On the other hand, the maker of the invitation to treat is not final in his proposal, and he has not committed himself to be bound. He's rather expecting proposal which he himself may consider or accept or reject. Then you make you give various cases. For nothing at all, the case of NTSC and entry will have to feature in your answer. Then the second part of the question, how has Ghanaian jurisprudence addressed the situation where the distinction is blurred? So the scenarios that we have when it comes to advertisement, advertisement in potential bilateral contract, advertisement in potential unilateral contract, you have to cite the cases. And let me emphasize that when you're doing law of contract question, if you don't cite any case at all, I can bet you the examiner is going to mark your question and half of the marks for that question. And you're not going to get like the full half. So meaning that you're already failing that question. So let's say that if the question is 25 and you've written a response and there's no single case, if I am marking, I'm going to mark you under maximum of 12, okay? And then the 12 is not likely that you get all the points. You're going to get like maybe 12 over 12 over the 25. So maybe your best answer, you're probably going to get about 10 or 9. So you're getting 10 or 9 over 25. It means that you're already failing that particular question. And that is why I would advise you that for each topic, please get the main cases, the main authorities, okay? Yeah, so advertisement, auction, tender. Yes, so if you're able to do this, I think you're making a good progress. Examine the doctrine of intention to create legal relation, with particular emphasis on agreement made in social and domestic contexts. Should the court adopt a more liberal approach in recognizing such agreement as legally binding? Okay, so this is very interesting question. You must, every essay question, you must have like a good structure. Your introduction, the body and the conclusion. But please, don't write just introduction, then write the word body and then conclusion. I think previously, some examiners complained that students with that elementary thing. You don't have to do that. So, intention to create legal relation, you have to make the point that to have a valid contract, there must be agreement or promise, but certainly not all agreement or promises are legally enforceable. And that is why intention to create legal relation is an important aspect of our law of contract. And for this purpose, our law puts contracts into two category or dichotomy. As we know, social and domestic commercial agreement. And then you make the point that the general position or presumption is that there's no intention to create binding legal relations, social and domestic agreement. You cite the cases, buffer and so on. Then you talk about like the exception. Now, then you also add that although the question also mentioned commercial, but you still have mentioned that in commercial agreement, however, there's an intention to create a binding legal relation. Now you come to the other part of the question. Should the court adopt a more liberal approach in recognizing such agreements as legally binding? Now that is where you go back to merit and merit. And then the case of, what is it? Simpkins, and Pace. And you make the point that if you look at, merit and merit, Simpkins and Pace, you notice that the court paid more attention to the actual circumstances, the actual details, rather than just simply, saying that this is a domestic and social, and for that matter, it is not binding. And that approach is more welcoming, meaning that in deserving cases where you have contracts in social and domestic agreement, the court can still go ahead and hold same enforceable, as it has done in those cases. But of course, if you read the actual decision, if you read the full case itself, or Bafo and merit, you notice that the court articulated the policy reason as why the common law said that contract between in the domestic setting, especially between spouses, should not be enforceable. Because they're making the point that if that were to be the case, the court would be inundated with so many cases with that floodgate argument, since every now and again various promises are made and so on. I mean, that same question put in different way. Analyze the role of public policy in determining the existence of intention to create legal relation in contracts involving governmental bodies in Ghana. How has it usually balanced the interests of private parties against public interests? Now, this case, the case of the City and Country West, right, against Accra Metropolitan Assembly, is a case about which has to do with the illegality in public policy, but also relevant to this type of question. If you remember that case, that was where the City and Country West Limited, having provided services for benefit of the AMA, when it was time for them to pay, they didn't pay. The matter came to court, and the AMA put up the argument that there were certain statutory procedures they ought to have followed in making the contract, and because they didn't make that, the contract was not valid and not binding. And as you remember, Justice Dateba said that we don't have to follow the strict common law approach that where the contract is illegal and so on, then no payment can be done under it, and that we need to use a structured approach to find out, so that on case-by-case basis. And in that particular case, as he said, yes, the City and Country West could not be blamed because they don't control the internal processes of the AMA. The AMA has its own statutory procedure. If it doesn't follow that, and a private party or a third party like the City and Country West has actually entered into transaction and has provided a side obligation, they cannot escape performance of their side by hiding behind non-compliance with their own internal statutory procedures. So please look at that case in addition to all that we'll discuss with respect to intention to create a legal relation. So as I move on, if you have anything to add or anything to ask, then you draw our attention before we move on. We also have this question. Consideration is often described as the price for which the promise is bought. Critically evaluate this statement in the light of the doctrine of consideration and the Ghanaian contract law. How does the concept of past consideration fit into this framework? So I'm very, we've discussed consideration not too long ago. So you have to make the point that consideration is a requirement where we're dealing with a simple contract. That is the contract not under deed or contract under seal. And for that matter, it is necessary for the court to establish the genuineness Okay. Mic is back. Yeah. Okay. So now we're looking at the question 5. And I said we've basically discussed what you need to address that unless you have any particular question or difficulty, in which case we will discuss them. Otherwise, I don't need to belabor the point. Let's look at 6. Debate the necessity of doctrine of consideration modern contract law. Should Ghana move towards a more flexible approach akin to the doctrine of promissory estoppel or retain the traditional doctrine of consideration? Okay, this question, for example, is testing whether you understand where Ghana law is. First of all, promissory estoppel, as we indicated in earlier discussion, emerged to address or mitigate the unfairness associated with the rule in the Pinel's case, the part payment problem, if you remember. But however, in Ghana, by reason of our Contract Act, particularly Section 8.2, which make room for waivers and all that, if there's a promise to accept or to waive debt and it's not supported by consideration, same is still valid. So that traditional doctrine to start with, since 1960, is no longer applicable in Ghana. And so, yes, promissory estoppel, by reading of Section 26 of our Evidence Act, is still part of our law, but those situations in which it was needed so as to overcome the difficulties posed by the rule in the Pinel's case of Osembe and all that are not necessarily necessary or will not happen in our jurisdiction by reason of these changes which we have in our law. So I should just draw your attention to that, in addition to all that we've discussed concerning consideration and promissory estoppel. Question 7, critically assess the capacity to contract under Ghanaian law, particularly focusing on the challenges faced by minors, persons of unsound mind and corporation. Should there be further legal reforms to better protect vulnerable parties? So this question, twofold. First of all, is invitation for you to provide an exposition and also evaluation of capacity of minors to contract, capacity of persons with unsound mind to contract, and capacity of companies or corporations to contract. That is essentially what the question is asking us to do, to find out. Yes, the first point to note is that the law on capacity recognizes that not all parties to a contract may have the necessary abilities and competencies regarding complexities of transaction in terms of taking good care of their own interests. And it's necessary for the law to protect them. And that is why the law is there to set the ground rules for certain category of parties when it comes to certain types of transactions. So therefore, every adult, as we have indicated, is presumed to have the capacity to contract so long as he or she is of sound mind, compos mentis, as it were. However, where the person is not an adult, but is an infant or minor, in which case the person is below the age of 18, he is likely to be exploited by unscrupulous adults. So there's a need for them to be safeguarded from exploitation of their vulnerability. And for that matter, the law recognizes that they may enter into certain contracts which are needed for their welfare, contract for necessaries, contract for beneficial service. But even those contracts, the law still intervene to protect them so that they are not made to just pay a contractual price, but what the law considers to be reasonable and fair. You know all the things that we discussed in Nash and Iman, the Sale of Goods Act, definition of necessaries and all that, you go back to them. Then again, you also make the point that there are certain contracts which the law says that in contract for beneficial service, where they contain terms which are considered undesirous or undesirable or onerous, then those clauses may not be binding, despite the fact that the contract is a contract for beneficial service. And again, there are certain contracts which are considered no-go and automatically they are void. For example, contract for loans, by minors. The exception being that in Ghana, we take like the student loan scheme, beneficiaries of the scheme are considered to be adult regardless of their actual age. Then you talk about persons of unsound mind. The fact that, so when it comes like the minors, the evaluation side, if you look at it, are you satisfied with how the law is? Does the law not give an unbalanced protection? Is it all, if you read, Mrs. Zona Hammond has an article, but the main focus of the article was trying to have a uniform majority age, because previously the position of the law was not, clear. At the time that she did the article, we didn't have like, the Companies Act 2019 and the Interpretation Act of 2009. So she was making the point that it would be useful to have like a uniform age instead of having the Children's Act saying this and other legislation and other things. But more importantly too, she also addresses the issue as to whether the justification which the law provided for giving a certain preferential treatment to minors when it comes to contracting, whether that justification is still there, or having regard to changes in society's development and all that, children are maybe sometimes better enlightened, and for that matter, some children may rather even want to exploit adults. And if that is so, should they benefit from the level of protection which the law gives them as it were? Well, the evaluation aspect is for you to just bring your own appreciation of the most important thing. You should be seen to be doing a little bit of thinking, but there's nothing like absolutely correct or wrong answer, okay, when it comes to this aspect of examination. Then when it comes to persons of unsound mind, as you know, if you look at the Mental Health Act, everyone is presumed, and also the Evidence Act, everyone is presumed to be of sound mind. However, where that presumption is rebutted and You know, persons of unsound mind, they are supposed to have what you call the guardian ad litem. That is the people who are supposed to be in charge of their affairs. But assuming you entered into contract with them during times that their insanity, for example, seem to have gone down. No, we are not talking about, people who are 100% of, for them, there's no way that you can enter into contract with them. But you're talking about those who have a mental condition and it's like it goes and comes, that kind of thing. That's what they're talking about. So there are times that, especially if you have people who suffer from schizophrenia and those kind of things, there are times they come to their normal times, lucid intervals or moments, and there are times that their condition will kick in. So if you made a contract at the time that they have come back to the state of normalcy, then if later on the person seeks to flag his unsound mind as an excuse, you have to also bring evidence to overcome whatever case that he or she will have made, that yes, this contract was made at the time that he was not of sound mind and he couldn't have intended such a contract. Then you will need to counteract it. So we have like a reverse burden of proof, as it were. So the person of the unsound mind, he will have to bring evidence to show that he was of unsound mind at the time that the contract was made. So that is a reverse burden. And then if you take like the corporations, previously, capacity of corporation used to be important, but now it is not, especially under the current Companies Act of Ghana. Previously, we used to have something called a doctrine of ultra vires, because corporations or companies were supposed to have what we call the object clause in their constitution. What used to be called their regulation, but now we call it the constitution. And the object clause was supposed to state the scope of things which the corporation or the company could actually engage in. And for that matter, if the company, for example, entered in a transaction which is not covered by its object clause, that transaction, among other things, was ultra vires and all that. And same will not be applicable. And you remember also the rule in the Tech One case and all that. But under the current dispensation of the law, the object clause is not mandatory. And for that matter, corporations have full capacity, like natural persons. They can enter into all manner of contract and transactions, as it were. Evaluate, yeah, so somebody was asking a question about capacity. When we're at question 1, that person can speak now, because we are still in the area of capacity. Okay. Yes, you can unmute yourself. Yes, Muhammadu.
Okay, sir. Hello.
Yes.
Okay, thank you very much, sir, for giving the opportunity. With regards to the age, the age being 18 or 21, so, I don't know, with the Donna Hammer book, she indicated that currently, that I don't know whether the book was written earlier before what you said came into existence, that there is no clear position regarding to whether it should be 18 or 21, but that until we get a contractual an act coming out to clearly define it, that now we should go by the 21 with the common law position. So I don't know. That's my problem now.
Yeah, but I will suggest to you that if you write 18, you will always be more correct. Okay.
Okay, sir.
If you write 21, you need to make the arguments that you are making. The fact that
Okay,
different
sir.
enactments provide different ages. This provide this provide that, this provide that. And the common law is 21. But if you go to England, there's what they call the Minors Contract Act. It puts the age at 18 over there. But of course, that legislation is not applicable to us. But as I said, a question like this has come before, and my understanding is that if student wrote 18, so long as they explain as we have said, it will not be marked wrong. Okay.
Okay, sir. Thank you, sir.
Evaluate the effectiveness of legal. I think a similar thing, that just putting it in a different way. Evaluate the effectiveness of legal mechanisms in Ghana that address the capacity contract, especially in cases involving persons under the influence of intoxicant. Should the law impose stricter standards to safeguard certain individuals? Now, of course, it's similar to what we discussed with respect to those of unsound mind. If you are drunk or intoxicated, you will have like the burden to prove that you lack sobriety or you are not in your sober moment at the time that the contract was made. And then the person seeking to enforce may have to bring a counter evidence to rebut what you are saying. But you have like the burden to start with. Yeah, so we have a scenario like this. Kofi offers to sell his car to Amma for 50,000 via email on Monday, stating that the offer is valid until Friday. Amma replies by email on Wednesday, stating that she is interested in purchasing the car for 45,000. Kofi does not respond to this email. On Friday morning, Amma sends another email accepting the original offer of 50,000. However, Kofi had already sold the car to another buyer on Thursday evening. So discuss the legal issues arising from this scenario, particularly focusing on concept of counter offer, acceptance, communication of acceptance, and the Ghanaian law. We see if map out the, if you like, the issues or what we want to concentrate on for you. Then some entitled to any legal remedy. So this is a problem-based question, and as we always tell you, when it comes to problem-based question, you must approach it like how lawyers or judges think about problems. We use like the structured approach, which is the IRAC or the IPAC. You must identify your issues. Some will say that area in the issue is fine. If you have area in the issue, that is fine. You just have the issues, that is fine. The critical things are the issues. Then you should take the issues one after the other, and then you state the relevant principles or rules of law together with the authorities out of which the rules of law are actually extracted. You have to state them against them. And then you need to do the analysis and application. You need to show whether the facts before you satisfy the particular principles that you have stated. If it does not do, you need to point it out. And in doing so, it may well be that case law, which support these principles in terms of their factual configuration, coincide with the factual scenarios that you have, or they don't. So you need to do some distinguishing here and there as the case may be. Then, of course, when you finish with all the issues along that way, you have your major conclusion and you pull everything together. And in this particular case, so you've been asked whether Amma is entitled to any legal remedy, and all will be answered as part of the big conclusion. So I think this is something that you can all do. So we will not belabor the point, except that as you have been directed, the issue of counter offer has come in. So look at it. Can somebody generate issues for us? Yes. And previously, we have said that when you are doing issues, go line by line, okay? You go line by line. So you ask this. Is there any issue here? Muhammadin, okay. Yeah, Muhammadin.
Yes, sir. So with this one, I don't know, I can say that whether or not the offer given by Kofi to sell his car to Amma for 5,000 via email, then the promise to keep it open is binding on him.
Okay. Okay.
Hello?
Yes, we are listening to you.
So that's what I'm saying. I say whether or not the offer to sell to keep the offer open, selling his car to Amma till is binding on him. So
Okay. People are saying they can't meet themselves. Okay, let me just. I'm releasing all of you, but only one person should be talking at a time. Otherwise, we will have the jammed classroom. I think you can mute yourself. Okay, I mean, that is fine. How we formulate the issues may vary, but the most important thing is that the central idea should be there. And of course, in a question like this, the question taskmaster has directed you what you should be focusing on, so it becomes a bit straightforward. He said that they're focusing on, let's say, the counter offer. So acceptance, communication of acceptance, and so on. So your mind has been directed, and along that line, that is also stating. So whether the offer by the offer by Kofi to keep it until Friday is binding. Certainly, having section 8.1 in mind, that is something that you still have to raise as well. Okay, yes. Kiki, something you wanted to speak?
Yes, so on the second one.
Yes. Okay, the second sentence.
Okay. Whether or not Ames reply to purchase the car for 45,000 will amount to a counter offer.
Okay. Okay, that is fine. Yes, Elizabeth. Elizabeth, you can speak.
It's the third one, whether or not Ama's acceptance of the 50,000 later will be valid or will be an offer.
Okay.
Yeah, whether or not the 50,000 acceptance of Ama on Friday would be valid.
Okay, if you do that, I would like you to put the word acceptance. Elizabeth, you use inverted commas. You put acceptance in inverted commas. Okay.
Okay, okay.
Yeah, because
Thank-
as whether it is acceptance or not, it's yet to be,
Determined.
yes. Are we done? Do we have any other issue? Yes, the hands, the same or the new hands up. Is it okay? Is it Mahamadu Elizabeth? Yes?
Yes, sir.
Okay,
Mahamadou.
right.
Okay. So with this one, maybe one can also ask the issue that whether or not I can see it. Where the person sold the edition, I can't see, sir.
You can see. Okay.
It's like you have taken.
No, it's the color I'm using.
So here, whether or not the sold made by Kofi to the another buyer was valid.
Okay. What is the legal effect of the sale? Okay, all right. So how many issues we have? How many issues do we have?
4.
Okay.
But I'd like to raise the remedy, whether there'll be any remedy available to the
Wama. Okay. All right.
party.
Okay. So you have your issues, you know the law, you know how to do the analysis and draw conclusion thereon. Is there anybody who needs assistance? Otherwise, you're moving on to the next question. We've discussed the necessary law today, and the issue here, what we've discussed, should be able to. Okay, there's somebody else asked a question. Whether or not there was a valid contract between Kofi and Nama, and then address all the issues instead of stating the issue one by one for the sake of time. Okay. As a good question. So somebody is asking, in order not to waste time, can we just create one big issue? Whether or not there was a valid, let's say, contract between Kofi and Nama. And within that, we do all the discussion. Well, my answer is yes and no. Yes, if, for example, we can take it for granted that you are sufficiently matured in the law and having a general issue, one big general issue, you will still be able to remember to discuss all the, the sub issues that we are talking about. If you can, that is fine. But the danger is also that you have the marking scheme, and usually marking scheme will say that the students should raise issues, a certain mark should be given. So if the marking scheme is, for example, expecting, let's say, at least 2 issues or 3 issues, I'm just put one general one there, your fate will hang upon the discretion of a particular marker or examiner. And you don't want to play such a gamble. So I will prefer that you use the long route. And for the long route, if you use it, the advantage is that you will not go wrong and you will not miss or leave out any issue which needs to be raised. Yeah, that would be my advice.
Yeah.
Okay, so let's look at question 11. Auntie Akosua promises her nephew Kwame that if he gets a first class degree, she will give him 10,000 Ghana cedis to start a business. Kwame, relying on this promise, works hard and graduates with first class honors. When Kwame asks for the money, Auntie Akosua refuses to pay, claiming it was just a family promise and not legally binding. Yes, analyze whether Kwame can enforce a promise made by Auntie Akosua. How does the concept of intention to create legal relation apply to this case? Okay. Will anybody lead us to discuss this? Yeah, Muhammad, yes.
Okay, sir. So here, the area of law is already communicated that intention to create legal relationship. So with my issue.
Okay. Well, that's why the fact that the question said, how then I will also suggest that you add consideration to it. Okay.
Okay. Okay. Okay. So with my issue,
and somebody may even go to the sense of adding capacity, but except that we don't have enough information, isn't it?
Okay. Okay. So can I proceed, sir?
Let's do. Yes, proceed.
Okay, so as you said, the area of law is intention to create legal relation and then consideration. So here, the issue I'm seeing only that whether or not the promise between Akosua and her nephew Kwame that if she gets a first class, she will give him 10,000 was binding on her. So the general rule is that when parties enter into a contract, it is intended to be binding unless there are express provisions that state otherwise. So in this case, in a situation where parties enter into an agreement which is mostly on domestic or social grounds, the general rule applicable there is that they are not intended to create any legal relation, except in a situation where the agreement is on commercial basis between those parties. So here, like in the case of Jones versus Padavanton, where the mother promised the child that if she's able to take her study seriously, like she'll be given the rent of her house in that country. So applying these rules to the case that we have at hand here, it is clear that Kwame was a nephew to Akosua, and this one was just a promise to make Kwame perform or do well in the exams. So there was no any intention to create legal relation, and therefore Kwame cannot enforce such a contract.
So you have any authority to support that?
Yeah, Jones versus Padavanton.
Okay. I mean, you've done well, but the one comment is that if you look at the question, you see the intention to create legal relation is just an aspect of the question. Is that the follow-up?
Okay.
So you look at, you said that analyze whether Kwame can enforce a promise made by Ante Akosua, another law of contract in Ghana. So the question is a bit general. So I would even like to see consideration, the issue of past consideration. I would like to see capacity, except that the capacity, you make the point that despite the fact that Kwame is a student, we don't have enough information to conclude whether he has
about the age.
But then you just raise it just to let you. But then the past consideration aspect is the heart of the question. And then the intention to create legal relation is the subsidiary part. So because look at it, the promise was made, and then subsequently he works hard and get the first class honors. So do you see the issue of consideration there?
Yes, sir.
Yes, can you speak to it for us?
I have the case of Hammer and Seedway in mind. I don't know whether that is what fits the bit.
Tell us about it.
Okay. It was a case where then the uncle asked the nephew to not to do a particular thing, and then after a period of time, he will be given a certain reward. So kind of like forbearance. So he obeyed the uncle's instruction, and then at the end of the day, he enforced the contracts, but the uncle was of the opinion that no, that was just he would not give whatever he promised, but the court was of the opinion that because he has given out up on something, a right that has accrued to him to obey him, the contract should be enforceable. I don't know whether made sense.
You talk about forbearance.
Yes, please.
Mm-hmm.
But do we see forbearance in the facts of this particular scenario?
No. He was not doing something.
Okay. Okay. Then please, I'd like to be corrected.
Okay. So can we say that he worked hard to get the first class because of the promise?
Yes, please.
So in which case, past consideration will not apply?
Yes.
Yes.
Okay. Anyway, when you have a problem-based question, two things: correct identification of the issues and correct statement of the law. That is the barest minimum. Now, when it comes to the analysis and the conclusion, there could be some differences here and there. That is fine. But there cannot be differences regarding what the correct position of the law is and what the relevant issues are. 12. Salom, an IT specialist, agrees to face an issue with Mawuli's computer as a favor. After facing the issue, Mawuli, grateful for Salom's help, promises to pay him 500 Ghana cedis for his service. A month later, Mawuli refuses to pay, arguing that there was no binding contract. Yeah, so discuss enforceability of this under the Ghanaian law of contract. Will anybody give it a try? Yes, Mahamadou.
Yeah. So this one, my area of law will be consideration with specific reference to a past consideration.
Okay. So
can I move on?
Yes.
Okay. So with my issue will be whether or not Maule is bound to pay the 500 as promised to the other guy,
Okay.
the artist specialist. Good.
Okay.
So now the general position of the law is that when we talk of past consideration, it simply means that when a person performs an act which he later wants to use that act as a consideration to rely on a contract. So, however, there is an exception, and this type of past consideration is not sufficient to for someone to rely on it in order to enforce a contract. But however, there is an exception to this rule, which indicates that if, even though it is past consideration, if the other party promised the one who performed the past consideration that he shall maybe enforce it or maybe do something, even though it is past. For me, maybe he's just happened, he wanted to say, oh, what you have done, I am going to do this. Then in this case, the other parties rely on the promise made by the other person, and then the past consideration becomes sufficient consideration. So applying this to the rule, the facts that we have, even though the IT specialist performed the work earlier, which amounted to past consideration, and Maule then later promised him that he shall pay him 500. So this promise made by Maule is making the past consideration a sufficient one, and therefore the IT specialist can enforce the contract in order to get the 500 Ghana cedis. So my conclusion is that Maule is bound by his promise to pay the 500 Ghana cedis to the IT specialist.
So are you
Thank you.
saying that your analysis is on all fours with the case in the Lampton and Brightwood?
Yes, please.
Okay. Well, my comment is that, again, as I have said, you have to get the correct issues as he attempted, and then you must state the law well. But as with the analysis and the conclusion, the equivalation, somebody can argue that what you have said is not really the case, and the fact that from the very start, Solomon made it clear that he was doing it as a favor. It was quite clear that he was not doing it in anticipation for any payment. And now if you look at the other case, in which the court said that if the act has been done at the request of the other, then subsequent promise to pay a reward could be enforceable here. Yes, that he agrees to face it, meaning that Maule had probably requested it, but he had indicated that he was doing it as a favor, that is as gratis. And that being the case, is distinguishable from those cases in which the court has held that if the act was done. So as I indicated, there's a question of how you understand the principle and then the facts. But the analysis and then the conclusion, we can differ, but you cannot differ on the correct statement of the law and then the issue. Yes, Elizabeth.
My Lord, thank you. So I wanted to find out if we can also go by way of one of the exceptions under past consideration is that the act is done by way of business. So you argue from that point and indicate that if it is going to be done by way of business, then it means that the party should have understood at the time of the performance that what is going, well, the
If you say by way of business, can you expatiate that?
So, by way of business, maybe this person is an expertise in IT, and that is what he does for a living. So, concluding, then I will indicate that, but for the favor that is mentioned, it vitiates the way of business. If he had not said for business, then we know that he fixed IT for a living, and we have an agreement. I'm coming to fix your machine for you. Then of course it is expected that I'm entitled to a remuneration, as in I don't know, Ray can say something. So
Ray McAdam.
no, Ray can
Ray
say
Cassie, stewards and patents, yeah.
yes, please. So then, but for the favor that was indicated, it would have been an act that was done in the course in the way of business. So maybe I'm driving my car and someone comes to wash the mirror of my car. The person is doing that in the way of business. So it is expected that remuneration will be given. But for saying that a favor will be, I'm doing it for you as a favor, that vitiates that particular this thing. So maybe I want to find out if we can start in that way and come to conclude that had it not been for the favor that was indicated, it would have been expected that for someone who is an IT specialist working for, for a benefit, it is expected that a remuneration will be given to the person.
But don't also forget that the law is worried of busybodies, isn't it? If you're on the frolic of your own, if you are on the frolic of your own, and if you're also extrapolating it, you can also even go to the extent of silence. All those things will come in. Yes, somebody, unless if it's about like he having requested you, then that is different thing. And let's say that if he has not requested you and you've seen a need and you think that is where your professional expertise are, intervene on your own to go and provide the service, thinking in your mind that perhaps when I finish, this person may give me something. Now, the two are different. Where you have been requested, at the time that request was made, no payment was promised, but subsequently the promise was made. As in the land play type, that is fine. So if you look at the Ray Cassie patent, for example, when Cassie completed his work, he had worked for the patent owners, the defendant in the case. Now, when he had completed, the defendant as the patent owners made a promise to him that they'll give him 1/3 share in the patent as a reward for his efforts. And later on, they decided not to make good that promise. But the court recognized an exception to the general position of the law. And Lord Justice Bowen would make the point that the promise was enforceable and valid because Mr. Casey had done the work under circumstances where it was implied that he will be rewarded. Now, if you look at it carefully, the emphasis is on the fact that he had done the work at their request. So, like your scenario, if the emphasis is on the fact that he being a professional have been requested, maybe the aspect of the fact which changes the scenario is the emphasis that he said he was doing it for a favor. Maybe that is what can be harped on by anyone who wants to argue that maybe the exception to the past consideration will probably not apply. But apart from the word favor is on all fours with the other in Ray Cassie patent and also even the Lamplin Brightweight case, as it were. But as I have indicated before, the crucial thing is you stating the correct law, identifying the issues. But the discussion, the conclusion, there could be some slight differences here and there, and that is fine. Let's look at another question. I'm getting tired, and then we'll probably let me just read the question, then I'll just leave you later on when I have time, then I'll come back for you. I've been a 17-year-old minor enters into contract with a 25-year-old trader to purchase a motorbike for 5,000 cedis. Abina pays 3,000 upfront, with the balance will be paid over the next 6 months. After using the motorbike for 2 weeks, Abina decides she no longer wants it and seeks to avoid the contract, and she wants to demand the return of 3,000 Ghana cedis. Good. Can Abina void the contract and recover the money paid? Okay, you can take short of that and then you can discuss it and solve it later on. So let's see, question 14. Discuss the role of consideration the formation of contract. We discussed this similar question before. So examine the doctrine of Privity of Contract and evaluate how it has been modified in the Ghanaian law. So this is straightforward question. You have to tell us the doctrine of privity, what it basically means. We've explained it over and over today. The fact that originally at common law, contract does to create rights or obligation for third parties. That the position of the law is that you must have provided the consideration before you can enforce the contract. So consideration must proceed from the promisee to the promisor. Jordan and Atkinson, and later on, the case of Dartin and Poole will tell us that if the consideration is provided by even someone related to the blood, but that is not important. So we just focus on the main propositions of the law. Then you state the point that the common law was against creation of a third party rights and the contract, what you call the use tertium quasitum, and then the case of Dunlop against Selfridge. Trading and all saying the same thing. You can briefly tell us about the facts of Dunlop and Selfridge to illustrate the point, or Trading and Atkinson to illustrate the point. Then you make the point that at common law, some exceptions, emerge to circumvent this privity rule, as we've seen: trusts, assignment, agency, bilateral contracts, restrictive covenant, and all that. But in Ghana, we have made a direct modification of the law, and we've actually recognized creation of third-party rights in terms of Section 5, 1 of the Contract Act. Now you explain. And then straightforward. Let's 16. A farmer offers to sell 100 bags of maize to be a trader for 10,000 cedis. B agrees to buy the maize, but asks A to deliver it to his store by the end of the month. A agrees, but does not deliver the maize at the agreed date. B, who had already entered in contract with C to sell the maize at a profit, is now unable to fulfill his obligation to C. B sues for breach of contract, and C also attempt to sue A for the losses incurred. Yes, yeah, so advise the parties The simple scenario, but interesting, isn't it? Then 17, and then we've basically, okay, so let me just tell you the question and leave. S promises to give Y a car as a gift on Y's birthday. Y in anticipation spends 2,000 cedis on car accessories. On the day of Y's birthday, S changes his mind and refuses to give the car to Y. Y sues S for breach of contract. So question, is Y entitled to enforce Y's promise? S promise? B, analyze the requirement of consideration and relevance of promissory estoppel in this case. Will you answer change if Y had promised to pay X 1 Ghana cedis in exchange for the car? So just take the questions and then you try your hands on them on your own later on. And the last question for this team 1 session. P enters into a contract with K, agreeing to supply K with construction materials. The contract specifies that K's clients who purchase completed buildings are to benefit from a 10-year warranty on the materials. One of K's clients discovers defects in the materials within the warranty period and seeks to enforce the warranty against P. A, can R enforce the warranty directly against P? Discuss application of Section 5 of the Contract Act, 1960 Act 25. And finally, how does the concept of privity apply in this scenario? And are there any exceptions or statutory provisions that R can rely on? Okay, have a good afternoon. When we have the time, we'll meet you again in the evening.